Hi! Today we're starting a series of talks about distribution agreements worldwide. Our experts will tell us about the main features of distribution contracts in their countries and share practical tips on negotiating and drafting these agreements. Our first speaker is Ignacio Alonso from Madrid, interviewed by Roberto Luzi Crivellini. In this episode, they'll discuss how distribution agreements are regulated in Spain, what are the important clauses in these agreements, what are the main issues in distribution agreements, and how to prevent or manage conflicts. Make sure you follow Legalmondo on LinkedIn and YouTube to stay updated on the next episodes.
Hello, Ignacio. So, as a first
Hello.
as a first episode of this series of talks on distribution agreements worldwide, I thought we could start from Spain and understand how distribution agreements are regulated in Spain.
Thank you, Roberto. Well, it's quite easy, this question. In Spain, we have not a specific law on distribution agreements. So everything is regulated by the decisions of the court. It is true that although we do not have this specific law on distribution agreements, courts tend to use the agency law to regulate some aspects of the distribution. So it is important to know the agency law for these specific agreements, which is a law similar to other European Union countries because it's based on the EC directive. So it's easier to understand how it is regulated. But the main question is we do not have a specific law on distribution. We have to care very much attention to what the courts say for specific topics, of course.
Okay, thank you. And do you have any practical tips that should be kept in mind when negotiating a distribution agreement with a Spanish counterpart or to be performed in Spain?
Yes. Well, the main question when negotiating a distribution agreement is to have clearly in mind what do you want to regulate, because in our country the contracts is what the contracts are, not what the parties call that contract. So it is important to have clearly in mind what do you want to regulate. Is that a real distribution agreement, or is that an agency agreement, which is in some cases quite similar, or parties do not know exactly what they want? And courts usually, the main question that the courts are considering is what kind of agreement we are facing, because as I have previously mentioned, we have an agency law, but we do not have a distribution law. So the first question is that an agency, or is that a distribution? Is that a provision of products, for example, is not a distribution, but I'm selling products on a regular basis. Is that a distribution agreement or not? So the main question, the principal question you have to deal with your counterpart is to decide what kind of agreement you want. It is also important that because one of the main issues of the distribution agreements is the termination of the agreement. Is there an indemnity, a goodwill indemnity, a compensation for the client? It depends if it is a distribution agreement, if it is a simple selling of products to the other party, or if we are in an agency agreement. So it is very important to clearly set what kind of agreement you have. That's the main question. Of course, you also have to deal with some other specific clauses, such as exclusivity, definition of the products, for example, non-competition after the agreement. So there are many other, the applicable law, how to solve the problems, for example, in court, arbitration, or Spanish law, or Italian law. So it is also, there are also many other aspects you have to deal with when you negotiate, but I think this would be the summary of the most important.
Okay, thank you. And what are the most common disputes for foreign manufacturers distributing products in Spain, if you have to mention, based on your experience?
Yes, well, I would say that the main, or the principal one is just this, the one I have mentioned before, to decide if this is a distribution agreement or not. I remember one of my first cases in which there was a simple, when the manufacturer wanted to terminate the agreement, he sent a two-line letter saying, "We've end our relationship." The main problem there was to decide if this was a distribution agreement or not. And the second one, or maybe also the first one, is the dispute on the compensation when the agreement terminates. That's also the main point, because of course the manufacturer doesn't want to pay anything, and the distributor always asks for something. So that's, I would say, the main two aspects discussed in courts or when the conflict arises.
Well, thanks for mentioning that. And I had myself a couple of cases a few years back where we had the issue of litigation on termination indemnity after completion of a distribution agreement, which is something we don't have based on Italian case law, and I know most countries do not have.
Mhm.
And, so thanks for bringing that up. And how would you suggest to address that point from a contract drafting viewpoint?
Well, since we do not have a distribution agreement law, in the negotiation of the agreement, it depends if you are the manufacturer or the distributor, of course, because the goodwill indemnity or the compensation at the end of the agreement is not compulsory as it is for the agency agreement. So parties are free to decide if they pay, if they prefer not to have this compensation. They can regulate as they want, a fixed amount or whatever. The problem is that if you do not mention that in the agreement, then the agency law will apply. And then you will have to consider a goodwill indemnity, even if the parties have not mentioned that in the agreement. You are free to decide to exclude this compensation, but if you do not mention in your agreement, then the agency law will be applicable, and then you have to calculate how this goodwill how this goodwill is compulsory, is applied, can be asked for by the distributor.
Okay, so how would then a court decide on the calculation of the indemnity? Would it be by analogy what happens with an agency agreement, or are there different methods?
Basically, is the analogy with the agency law. The problem is that in an agency agreement, you have commissions, which is quite easy to calculate because, well, you have to take the commissions paid over the past 5 years. Calculate the 1 year average of these commissions, and then you have the maximum amount that an agent can ask. In a distribution agreement, it's a little bit different because you don't have commissions, you have margins, and then and here the problem is what kind of margins you have to consider, the gross margins or the net margins. And here we have in Spain a sort of conflict between some decisions of the Supreme Court, and it seems that the last case law is considering the net margins, which is not exactly an analogy with the agency agreement. But this is a maximum that the distributor can ask. The margins, the net margins perceived by himself of 1 year of net margins calculated as an average of the last 5 years. But this is a maximum. And how to reach that maximum or how to not reach that maximum depends on which side you are discussing. It will depend on several circumstances, and usually at the end is considered or decided by the judge. We do not have, like in Germany, for example, a sort of specific steps to be followed in order to calculate this amount. What is usually asked by the distributors is the maximum, but here you have to care attention because it's not always that amount that you have the right to receive.
I see. Okay. And I guess another point that should come up, at least that happens in Italy, for instance, is regards the prior notice, that it's either already indicated in the contract, or if there is no written contract, is decided by the parties. When is a period of prior notice sufficient? According to case law in Spain, it happened for me, for instance, in a case some years ago, that after an almost 30-year distribution agreement, the manufacturer got rid of the distributor with a notice of 6 months, and the court established that that was not sufficient, and then the period of notice should at least be, in that case, 12 months. Do you see often that kind of dispute? Yeah.
Well, again, since we do not have this distribution law, we depend on case law. It is true that in agency law, as you know, the previous notice is 1 month for every year in which the contract has lasted, so with a maximum of 6 months. So it depends. If you do not have any provision in your agreement, it is wise to respect this same analogy with agency law. If you have already in your agreement a specific previous notice, usually if you respect that previous notice, you will not have any problem. If you do not have any, it is true that the courts do not apply automatically the agency law. And what is more important is to avoid the abuse of right. I mean, in some cases, a shorter period of previous notice has been admitted, 1 month or even some days, depending on the case, on the situation. In other cases, more than 6 months are required. But as an idea, as a general idea, to respecting what is mentioned in the agency law could be advisable if you do not have any provision in your agreement.
Okay, thank you. My last question would be on dispute resolution. So, what kind of mode of dispute resolution would you advise to consider in a distribution agreement to be performed in Spain, whether it's a state court, if it's arbitration, if it's mediation? What's your take on this?
Mm-hmm. Well, I usually like to recommend mediation in distribution agreements because I think, because first, you do not avoid court or arbitration. I mean, if mediation doesn't work, you can always use state courts or arbitration. I will speak a little bit about that a little bit later. But I think mediation for distribution agreements is quite interesting, because and particularly if the distribution agreement pretend to continue. I mean, if the dispute is, for example, on a lack of performance, because, for example, when the distributor has not purchased enough products of the manufacturer, which was mentioned in the agreement, or because there is a sort of violation of the exclusivity, but I want to continue with my distributor, and the distributor, of course, but I don't like the situation in which we are managing our relationship. In these cases, mediation is perfect, in my opinion, because we can solve the problem without breaking the relationship. And the relationship, the distribution agreement will continue, but we have solved that part of the agreement. It is also interesting, in my opinion, mediation, because it leaves the conflict in the hands of the parties. The parties are free to decide if they prefer, okay, you have not paid, but I prefer to solve this question in this manner. They can also satisfy other conflicts, because, for example, I cannot reach you by the phone. You write an email which is cannot be accepted, or whatever. So other small conflicts or small situations that, of course, we will not go to court for these questions, but that can be solved also between the parties quite easily. And of course, it's also confidential, which is very interesting also if you have a distribution network which is a large one, and you do not want that one specific case with one distributor will spread with other distributors. And that's why mediation, in my opinion, is a good tool for this conflict resolution. And if mediation doesn't work, we can go to state court or to arbitration. And in order to decide if we go to court or arbitration, of course, we cannot have both. We can have a mediation with state courts or mediation with arbitration, but we cannot have in an agreement distribution. State courts, arbitration, or whatever. So there you have to decide a little bit in advance in your agreement. First, if you go to state court, which jurisdiction you may use, for example, Italy or Spain, which applicable law will you use, Spanish or Italian? And if you decide if you prefer to go to arbitration, which institution do you choose? Because for specific distribution agreement, you have to pay attention to the specific nature of the agreement. Not every arbitral institution could be interesting. Of course, arbitration is, in my opinion, a little bit more expensive. You do not have a second chance in case of arbitration, but you have a court of appeal in case of state court. So it depends a little bit of the parties and on these interests.
But now, based on your experience, what would be the most suitable for foreign manufacturers who distribute in Spain? What would you advise as a mediation as the first step? And then are you more keen on
Yes,
advising arbitration or state court?
I usually advise more state courts because this possibility of appeal.
Okay.
Because also because we have, even if we do not have a specific law on distribution, I mean, the case law is quite structured and quite repeated. So we have a sort of legal security, more or less. I mean, it's not, it's never, in law is never certain, but I usually prefer that also because we have this second chance, particularly because we have this second chance of appeal. And also because in some cases it is necessary some preliminary or provisionary measures. For example, if you want to seize some goods of the distributor, of the manufacturer, then state courts are the better, in my opinion, to I don't know, to block a bank account or to ask for information. And usually in arbitral institution is more difficult. So
Okay.
our mediation plus state courts seems to me a quite interesting approach.
Okay, thanks so much. This is a good place where we can wrap up this first chat. I noted the point on mediation, which I'm also keen to recommend to my clients and to insert in contracts in general, not only on distribution agreements. So maybe we will get back on this matter in one of the next talks. And for the moment, thanks Ignacio for this very informative talk.